Morning, guys. So this is the first case law analysis that I'm going to be going live on. So stay back and relax and enjoy. Thank you. So this case was about two people who had gone for refreshments in a club. So the people were Mwari and Radi. Mwari is the man and Radi is the girl. So when they were in this club, they were partying, all those stuffs, and the darkness approached. And Mwari suggested to Radi, you know what, let us go and spend the night to my place and I'll take you there. And when we arrive there, we will still add more refreshment. So Radi agreed and they walked together to Mwari's home. And unfortunately, it was time to sleep. But in the middle of the night, Mwari opened his eyes to see Radi stealing money from his clothes drawer. Mwari got furious and instead reached out on Radi and hit her a huge blow. Boom. Aya. Then he did not stop there. He continued to clamor her. In retaliation, Radi took a beer bottle, and smashed towards the head of Mwari. His scalp broke into two. Since he felt he went unconscious. Now, Radi did not stop there. He continued to stab Radi continued to stab Mwari with this broken bottle 6 times. So, don't be so quick to say that it was in self-defense. Do you know the principle that outline how self-defense would be applied? According to the Penal Code Section 17, it says self-defense will only be allowed where there are principles of common law that are applicable. In another video, I'll tell you what to say when you're accused of murder and not what to say. But in this video, Mwari succumbed to his death. Now, the issue is before the court, and the prosecutor is trying as hard as possible to get whether this Radi had actually what we called intention to murder, and whether there was actual murder in the first place. The intention to commit a crime is known as mens rea. In this video, I'm going to tell you the elements of intention and what the judges look for and what are the various case laws that they use to convict someone. So, before the court, did Radi intend to kill Mwari? This is the first case law, and its analysis is going to shock you. First, we must understand by what I mean by intention to kill as mens rea for murder. Intention is the most common and main level of mens rea. And an act or omission is not wrongful if found that the accused person did not have an intention to murder. Intention always requires the highest degree of fault of all the levels of mens rea. Therefore, a person who intends to commit a crime is more capable than one who acts recklessly. An intention to kill will most likely result you in a life imprisonment or a death penalty. But if the prosecution fails to discover you had mens rea, but you actually killed that person, actus rea is the action part, what the judge is most likely to give you is what we call manslaughter. Under Section 205, it has provided that for manslaughter, you will be penalized for life imprisonment. That is Section 205 of the Penal Code. Now, I want you to understand two types of intention. One, there is direct intention, stroke purposeful. and the other is oblique intention. For direct intention, it exists where the defendant has embarked on a course of conduct to bring about a result in which in fact it occurs. For instance, in our matter at hand, Radi wanted to kill Mwari, and to achieve the results, he stabbed her 6 times, and indeed Mwari later died. Hence, Radi's conduct achieved the desired result. The judge will be looking at is your conduct of stabbing the deceased, did it achieve the desired result that you wanted to kill that person? In relation to matters concerning murder, malice aforethought has been defined as an intention to kill, and it has been stipulated under Section 206 of the Penal Code. It provides circumstances under which malice aforethought shall be established as stated hereunder. The section states that malice aforethought shall be deemed to be established by evidence proving any one or more of the following circumstances. If you happen to find yourself in these two circumstances, the court considers that you had actual mens rea to commit the crime. You had premeditated that crime. One will be an intention to cause death or to do grievous harm to any person, whether that person is the person actually killed or not. There is also a separate video that I'm going to discuss on separate crimes in Kenya and people who have undergone that sentence concerning that crime. And you'll find that causing grievous bodily harm is a crime on its own, and it amounts to life imprisonment. However, if you happen to find yourself that you have caused a person grievous harm to an extent he has been taken to ICU and recently died, that will be considered you had malice aforethought. It is that intention to harm him. It is that intention for you to kill this person that he resulted in the death. So, number 2, that the judge will look at knowledge that the act or omission causing death will probably cause the death of or grievous harm to some person, whether the person is the person actually killed or not. Although such knowledge is accompanied by indifference whether death or grievous harm, bodily harm is caused or not, or by wish that it may be caused. This point says that if you had planned to shoot someone and by mistake you shoot somebody else, that knowledge that you had that gun, and when you will fire that gun it will kill someone, it does not matter whether you actually intended to kill another person. That is mens rea and it is murder. In the case of R versus Vikens, the appellant was stealing a house when the elderly house owner confronted him. To avoid being recognized, the appellant struck her many times. She died as a result of her injuries. The appellant was later convicted of murder. He appealed the conviction on the basis that he never intended to kill the woman, and so could only be guilty of manslaughter. He was pleading for a lesser sentence. He relied on Section 1 of the Homicide Act of 1957, a UK act, which abolished the notion of constructive malice, where a person kills another in the course or furtherance of some other offense. The killing shall not amount to murder unless done with the same malice aforethought, either expressly or impliedly, as it is required for killing to amount to murder when not done in the course or furtherance of another offense. The Court of Appeal in this case upheld the conviction and said, no, we find that the murder charges is enough for you. The defendant intended to inflict grievous bodily harm, which was sufficient to establish the mens rea of the murder. This was not the same as the abolished constructive malice, which allowed even minor violence in the pursuit of a separate felony offense to amount to murder if the victim unexpectedly died. There are also some principles that say that when you find a person and let's say he's in a critical condition, maybe he's a sick man, and you enter into his home with the intention of stealing, robbing with violence. Robbing with violence is a crime that attracts life imprisonment in Kenya. So let's say you find this man is sick, then you clamber him to death. The court will consider that you found this man in a vulnerable state. That is what you call the thin skull case. You must handle the victim as you found him. If you found this victim most likely to die in the next minute, handle the victim with care, even if you want to steal. In Libran 1991, the defendant first struck victim and knocked her to the ground, and then dropped her when trying to drag her into the house. She died from a broken skull caused by being dropped. It was held in the Court of Appeal that the defendant was guilty on 2 counts. First, the initial blow and the attempt to cover it up by dragging her into the house was part of one transaction. This man, maybe he was saying that I only dropped her to the ground, and the ground is what had cracked her skull. But the court will consider, but it was for your action that this girl or victim broke her head to her death. Another case that we must analyze is the case of Republic versus Nedrick in 1986, a court of appeal. The appellant had held a grudge against one Viola Forshaw. He went to her house in the middle of the night, poured paraffin through her letterbox, and set light to it. A child died in the process. The trial was held before the judgment was delivered in Maloney, and the judge had directed the jury as follows. If when the accused performed the act of setting fire to the house, he knew that it was highly probable that the act would result in serious bodily injury to somebody inside the house, even though he did not desire to bring that result about, he is guilty of murder. The jury convicted the victim of murder, and the defendant appealed on the grounds of a misdirection. In this case, it is important to note that there was a clear misdirection, as the Court of Appeal reviewed the cases of Maloney and Hancock Shackland and formulated a new direction from the 2 decisions. The judge had directly linked the accused to murder, and the jury had taken the conviction part to be a guilty plea. Conduct is a prohibited act which may involve an omission or a commission. A commission is a deed or the act. It is the doing part of an offense, and it must be prohibited by statute. Omission is an element of an offense where there is a legal obligation to on the part of the accused person, and if he fails to discharge that function, there is no omission if there is no legal duty. If you happen to be taken to an emergency ward in the hospital and the doctor fails to attend to you, that is an omission, and it can likely result to murder. Section 204 of the Penal Code further provides that any person who willingly does any act or omits to do any act which it is in his duty, it is the duty of the doctor to treat you, not being an act or omission specified in Section 243, by which act or omissions harm is caused to any person is guilty of a misdemeanor and is liable to imprisonment for 6 years. It was held in the case of Vickers. During this burglary at V's shop, D was discovered by V, whereupon D struck V several blows. V eventually died from shock due to general injuries. It was held that D was guilty of murder because he killed with malice aforethought, being implied from the fact that he intended to cause grievous bodily harm. At times, we also have negligence and recklessness when it comes to criminal murder cases. For a doctor, it will be looked in the part of negligence, and for recklessness, it will be considered that you never bothered. Even if you had committed the offense, your actions was reckless. Ruddy stabbing Maury 6 times. That is a reckless and a highly guilty conscious mind. Under Section 202 of the Penal Code, negligence amounts to manslaughter in an unlawful killing. This actually occurs in absence of malice aforethought, which, as per Section 201 of the Penal Code, has included the intention to inflict grievous bodily harm or knowledge that the act or omission will probably cause death. this being an ingredient that has already been successfully well laid down. In this case, negligence and recklessness will therefore not suffice, since the repeated stabbing by Ruddy manifests an intention to cause grievous bodily harm. In some cases, where a person has stabbed another person only once, that case will be analyzed later. It shows this person either stabbed him for accident, but when you continue stabbing and stabbing to his demise, then you wanted to kill the man. In the case that I've said I'll tackle, where a man mistakenly stabbed another only one time, the judge was so convinced to hand over a 7 years imprisonment. The case is Republic versus Peter Kithaka Kiriga. The witnesses in the case were in agreement that the accused went to the bar while carrying a panga and a walking stick, all of which he was told to surrender at the entrance of the bar, and an order of which he obeyed. He explained that he was from working in his farm and explained that he had a panga in his hands. When trouble started inside the bar, the accused did not rush to get the panga he had left at the entrance. This clearly shows that the fight had occurred was not premeditated. He nevertheless stabbed the deceased, which was the cause of the death. What we take note is the state of mind of both the accused and the deceased person. At the time the murder took place, they were both drunk, and it was allegedly he had drunk 20 cups of gunzo, a local brew commonly brewed illicitly. That means that the accused person was intoxicated. The judgment in R versus Peter Kithaka noted that although I did not find that the kind of provocation the accused received is strictly within the definition assigned to provocation under Section 208 of the Penal Code, the court found that the term provocation could be expanded to cover such instances where the passion is heightened through intoxication, like was obviously in the case of Peter Kithaka. The accused says that the deceased took his drink by force and drank it without its consent, and after the fight ensued, he drew a knife, which the accused quickly snatched, and he was getting away. He was held behind by the deceased. That, in my view, the judge's view, amounted to provocation, which offers the accused herein a defense and the basis by this court to find while he is not guilty of the main charge of murder, he is certainly guilty of a lesser charge of manslaughter. You must note that even if manslaughter has a life imprisonment, the judges will still look at mitigating factors, as for the held on the case of Francis Mrotetu. That is a separate video that you can have a look at. In the case, the court also found that the accused person was not guilty of the charge of murder, but was found guilty of the lesser charge of murder, contrary to Section 202 as read together with Section 207 of the Penal Code. In application of the rule, after we have analyzed all those cases, now let us come to our conclusion. If Ruddy had no intention to kill Mwari, he would at least have left her in the previous unconscious state. Why did Mwari continue to stab her, and yet she was unconscious? The fact that Ruddy flew away from the murder scene is another proof that he had a guilty mind and was vividly aware of what he had done as a result. Mwari died a few minutes later. Therefore, we can prove that Ruddy had the intention to cause the death of Mwari. When he stabbed her 6 times with a broken piece of bottle, Ruddy had also knowledge and a blameworthy state of mind that he had caused grievous bodily harm to Mwari. Immediately she lost her consciousness after being struck by the beer bottle on the head. The act must have been the cause of the harm expressed in the crime deliberately, leading to its consequences. Ruddy had knowledge of this act, that it would cause the death of Mwari. He allegedly stabbed her 6 times with a broken bottle when she fell unconscious after being hit on her head, and moments afterward, she died. The fact that Ruddy flew away was something that had put her on the wrong side of the defense. In this scenario, Ruddy had committed a misdemeanor, only theft, and on being discovered by Mwari, who strikes him with her hand, Ruddy in turn picks up one of the empty beer bottles and strikes her with it and continues to stab her 6 times and flees. This indicates that he intended to cause grievous bodily harm, which is a prohibited conduct, and it has led to the death of Mwari as a result. We distinguish this case from the above case that I told you on Republic versus Peter Kithaka on 2 grounds. In Peter Kithaka case, the accused had admitted that he had killed the deceased just moments after the act. In this case, Ruddy flees from the scene, and this manifests his intention to cause grievous harm. In the Peter Kithaka case, another area to distinguish is case the accused was intoxicated, and this had fueled up the provocation, as the deceased held onto him and drew out a knife, which the accused took and stabbed the deceased with. In this case, even though Ruddy was intoxicated, he was hit by Mwari. He was in the process of stealing from her, and this shows premeditation, since he even took what he had paid her. Mens rea is depicted by the fact that he was in the process of stealing from her, an act which he retorted with rage. In conclusion, when Ruddy stabbed Mwari 6 times, it is assumed that he knew the consequences and cannot say that he did not know that Mwari would die as a result of his conduct. Ruddy had premeditated on his intent to commit a crime when he was stealing from Mwari. We therefore find that Ruddy is guilty of murder contrary to section 202 of the Penal Code. Thank you for your attention, and thank you for hitting that subscription button. We'll be covering the most hardest cases in Kenya that no one is willing to talk about. Thank you.